Your name?
Susie Norman.
All right. And where are we on this, folks?
I just spoke with Ms. Norman outside, and she has a job starting in Seattle November 4th. So she's agreed to return the property by November 1st.
Is that right?
Well, I had a job. I was supposed to already be out there.
Yeah.
But the case got adjourned from September 24th to today.
Right.
So yeah, they gave me until November 4th to get out there and be on the job. So, but I also have another case in court in regards to this matter as well. This case is separate. He told me out there, this is a different case, but I'm here to fight, Your Honor, period. Because I'm here to fight. And you knew that. You knew that from the very beginning I came in this court. And that is the truth. And I'm here to fight for what is right.
Okay. But what case is that one? Is that before a different judge or?
Your Honor, I picked up a complaint on Friday, case number 241C3728. It's a general civil case. Been filed in general civil court. I picked up the service on Friday. It's a complaint handwritten. I'm not.
Give us that case number again. Okay. And is it signed to bar?
Nothing's happened.
Nothing's happened because you just picked up the complaint, so they've got to answer. Okay, that's before a different judge, before Judge Barr. So as far as this case is concerned, you're going to be moving by
the
first,
November 1st.
Okay.
That's the goal. But I mean, I have to be back in court for that because I want to see that through because it is attached to see my complaint that I filed. The case, because that is against Mr. Stanford, the civil case. So.
Okay. So I don't know what you're telling me. What are you telling me?
I was just saying that yes, November 1st. He wants the property back, but they're attached. So I will.
What's attached?
So it stems from the reason that I filed in the civil case is because of this case, because of this possession case.
Okay, but what's the base? Can I see a copy of the complaint?
Hopefully
It does claim that he didn't have a certificate of occupancy and stuff. But it's not really clear as to what.
Okay, so ma'am, what do you want to have happen in this case? I mean, you're going to vacate
in this case.
Yeah, you're going to vacate the premises. You said November 1st, correct?
Yeah. Mm-hmm.
Okay. Then it seems to me that one of the ways to do this would be to enter a judgment indicating that you got to November 1st to move, but not just make it a termination. I would reserve the issue regarding the escrow pending the outcome of that case. And then that way we'll just hold the escrow, figure it out, but it wouldn't be a redemption on this case. You just move out November 1st. That case would follow its normal course. We'll hold the escrow pending resolution of that case. Does that make any sense to anybody?
It makes sense.
Is that me? Okay. All right.
Your Honor, did I don't even know if you can tell me this. Since it was, so the reason that I got here in the first place on the possession was because I stopped paying rent.
Correct.
And I stopped paying rent for those reasons that I put in my complaint. So did I do something incorrectly that it's not in front of you any longer?
Well,
Since you know.
that may have more to do with how the court sets cases, because if you had filed that as a counterclaim, then the whole thing would have stayed in front of me.
Okay. And I was wondering, I didn't think I could do it because I've been in front of you with this possession case so many times. I thought that any other recourse was out of the question, like, because even when I came the first time, I was supposed to request a jury if I wanted it, and then I lost that.
Correct.
I didn't read the paperwork. So I was wondering if
Your Honor, there's no claim for money damages in our case. It's a possession case.
Pardon?
Our case is for possession.
Correct. And that's going to be resolved. And I think it might be that Ms. Norman may be asking why the case is headed someplace else and resolving that issue. Is your, I guess, what damages are you claiming on that other case, ma'am?
One, he did not have, his rental certificate expired.
No, I got that part.
And, all of the damages, I had the inspector from Pittsfield come in and inspect. So my damages are, I'm asking for all of my money back because he entered into a lease with me and he wasn't supposed to. And then the inspector came in and inspected the house, and there are like 12 different things that.
Okay, let me stop you for a second.
Okay.
So typically for me, and I can't say that I would find that way in this case, I can just give you a framework of how I deal with cases involving certificates of compliance. For me, the general framework is any future rent would not be due and owing because there's not a COC. I then would go back and try to figure out whether or not rent would be due, but then it would be only a question of how much rent would be due, because at some point you occupied the premises.
Correct.
The question is how much that's worth.
Mm-hmm.
And that would be the amount that you would have to pay. I'm not saying that that's the way that if I had that case, that's the way I would find. I'm not saying anything along those lines, and I want to make that very clear. Okay. I'm just saying that that's my general framework for how I deal with this COC types of cases, absent some ordinance which says that I have to do something differently. Okay, that helps you at all. How Judge Barr would, I don't know. Mm-hmm. I don't know. And it might be, just so that everybody's aware, because it involves this case, I would not think it would be, but it might be that case might get reassigned to me. I don't. I've got enough to do, but I mean, one more would kill me, or it might. But, you were worrying, but nobody cares.
When you rub your head, it was worrying me a little bit.
What?
When you were rubbing your head, reading my, it was worrying me a little bit.
Why is everybody picking up on something? I'm going to stop doing it.
Oh.
Everybody's trying to read me.
I would never.
Yeah, you would. All right. So why don't we do this? Let me ask you folks this. And
Mr. Sandberg keeps coming to the house unannounced as well.
Okay.
And I have a police report on that.
Wow. Okay. So
it's a lot.
It is. All right. So whatever way is going to be easiest for you guys. Okay. I mean, I don't mind people being mad at me and me making decisions. I don't. I don't know if you want to go and explain this case again to another judge. This is the seventh time you've been here on this case.
Right.
So if you want me to get that case then I can talk to the judge and I can just take it. But if you don't, I'm not going to be offended. Believe me, I'm not. But
Well, that would be my preference, just because you know, like you said, I'm here 7 times.
I've been here.
Yeah.
I
And
know.
if, you know, and if Mr. McCurdy
Your Honor, with
wants,
respect to the court, I would like to keep it to the bar.
Pardon?
I would like to keep it to the bar if possible,
You wanted to go to Judge Barr?
possibly.
Oh, go for it. He'll be happy to hear it.
we flip a coin.
No. No. If the parties were to agree, I'd take it. But if the parties aren't in agreement, I'm not going to be offended by it. It just goes.
Well,
to Judge Barr.
we
So-
definitely aren't in agreement.
Okay. So can you guys draft up a judgment for November 1st?
Your Honor, I can draft up a judgment, consent judgment. I might have problems getting Ms. Norman to sign. So.
Why?
I don't know if she agrees to sign it, but I've sent her conditional dismissals before we've agreed on it. She said she's not signing until the judge agrees to it. So
I did say that one time in front of it, like in the courtroom. I didn't want to sign it without you knowing, because
I
you
know.
rule in this courtroom. This
I
is
know.
your thing. And I want you to know everything that goes on.
I remember.
Yeah.
I remember.
So that was the
I
one
don't know
time.
Counsel, I don't understand that. We all just sat here. She said she's moving by November 1st. I said, prepare a judgment.
He doesn't believe I have a job either in Seattle. He questioned that just
Your Honor,
2 minutes ago.
That's not accurate.
That is
That's
accurate,
not
sir.
accurate.
Yes, it is.
Absolutely. I'm not here to argue about that. I'm here to argue about that.
100%. And I'm here to fight. And I said that. I was wronged in the first place, sir.
I asked for one.
Sorry. My apologies.
You guys want me to just set it for trial? I don't have a problem doing that.
Okay.
Okay, what?
I will go, if you want to set it for trial.
I'm just saying I do, but
Okay.
I asked for a judgment. It seemed like we were all in agreement. I asked for a judgment. And
Well, you know, the little remarks from Mr. McCurdy they're unnecessary in my world.
Your Honor, if the date of her file is after November 4th, it would be after the date she has to report to work.
are you guys done?
Me?
I don't know. You guys are talking, so I just decided to have another conversation.
Oh, no disrespect. I really don't want to.
It's okay. I'm used to being disrespected. So by him. I don't know why I said that. No, you're my boy. We're why are you shaking your head? Is that wrong? No. All right. You guys figure it out. Here's what I'm going to do. Non-jury trial, October 22nd, 2024, 9 a.m. I'll be here next Tuesday,
Thank you.
and we'll just try it.
Thank you. Again, my
I
apologies.
don't know what we're
for
trying,
being-
but we'll just try it.
Okay. My apologies for being disrespectful.
You are not disrespectful.
I feel like I was a little bit. So
What?
I said, I feel like I was a little bit,
To me?
but that was not to you, 100% not to you.
Oh, okay. Then I'm not hurt by it. Whatever you did. I'm good. All right. Thanks, guys. Been real. That was a legal term. No, after that, I'm not calling anymore. I am so done.
What was supposed to be a simple possession hearing exploded into a full emotional courtroom meltdown when Susie Norman stepped forward, determined to fight for what is right, while simultaneously admitting she had accepted a new job in Seattle starting November 4th and agreed to vacate the property by November 1st, instantly creating confusion about whether this case was ending or just beginning. The judge tried to keep things simple: move out by November 1st, hold the escrow funds, let her separate civil lawsuit against the landlord proceed in another courtroom. But Susie wasn't having it. She insisted everything was connected, claiming the landlord rented her a property without a valid certificate of occupancy, forced unsafe living conditions, ignored inspection violations, showed up at her house unannounced, and triggered police reports, all of which she argued justified her decision to stop paying rent and file a civil complaint demanding every dollar back. The judge calmly explained that because she didn't file those claims as counterclaims in this possession case, they now lived in a different court under a different judge, a procedural mistake that left her fighting on two legal fronts. As Susie spiraled into frustration over missed jury requests, paperwork she didn't read, and feeling boxed out of her own case, the judge broke down how certificate of occupancy disputes usually work. Future rent often isn't owed, but past. Rent becomes a complicated calculation based on actual occupancy, not an automatic refund. A legal reality Susie clearly wasn't prepared for. Things grew tense as Susie accused the landlord of harassment, surprise visits, and intimidation while the judge tried to broker a practical solution. Enter judgment requiring her to move by November 1st, reserve escrow money until the civil case resolves, and avoid turning this into a redemption battle. But agreement collapsed when paperwork couldn't be finalized. The landlord's attorney doubted Susie's Seattle job, and Susie refused to sign anything without the judge personally approving it, triggering open conflict in the courtroom. The judge, visibly exhausted, reminded everyone this was the 7th appearance on the same case and offered to take over the related civil matter, himself just to end the chaos, but only if both sides agreed. They didn't, Susie accused opposing. Counsel of disrespect repeated that she was wrong from the start and reaffirmed she was there to fight, not quietly exit. The judge tried again to steer things back to resolution, asking for a simple consent judgment, but arguments over tone, trust, and motives derailed everything. Finally, realizing compromise was impossible, the judge slammed the brakes on negotiations and did the one thing neither side wanted. He set the matter for a non-jury trial, locking everyone into yet another court date just days before Susie is supposed to relocate across the country for work. As the hearing closed, Susie apologized for her emotional outbursts, admitted she was overwhelmed, and said she was done calling anyone, emotionally drained, legally exhausted, and still facing eviction, escrow battles, and a separate civil lawsuit. What began as a landlord-tenant dispute turned into a brutal lesson in courtroom procedure, how missing paperwork deadlines, misunderstanding counterclaims, and mixing emotions with legal strategy can trap someone in endless litigation, where job offers, housing stability, police reports, and civil damages all collide under fluorescent lights. And just like that, instead of walking out with closure, Susie left with another trial date, unresolved escrow, 2 active cases, and the harsh realization that in court, passion doesn't replace procedure, and sometimes fighting everything at once only guarantees you walk away with nothing settled.